Good morning, everyone, and welcome to Doing Business, LLC, Inc., or LP. I'm Vinny Civitello, Communications Manager for the New Jersey Business and Industry Association. I would like to welcome Scott Borsack, who is a partner and chair of the business practice at the Lawrenceville law firm of Szaferman Lakind. Scott is closing in on 30 years of practice assisting clients with business formation, acquisitions, and tax issues. Scott also works with business owners to assist them with passing ownership to the next generation of entrepreneurs and their family. Scott is a frequent author and speaker on business issues and tax topics. A few housekeeping matters before we get started. Today's webinar is being recorded and will be emailed to you tomorrow along with the PowerPoint for today's presentation, so be on the lookout for those. I'd also like to draw your attention to the questions tab. Scott would be happy to answer all of your questions, so don't hesitate to write them in as they come to you. So now let's get things started. Scott?
Well, good morning, Vinny, and thanks for this opportunity to participate in this program today. As the materials show, we've got a packed agenda, and as Vinny mentioned, we're going to try to save some time at the end for questions and answers. So on today's agenda, we'll be talking about the various legal entities to consider for operation of a business in New Jersey. We'll talk about how these entities begin their legal existence, how these entities are governed or operated, what protections are afforded through the different choices that business entrepreneurs have. We'll talk about tax opportunities as well. And let me say from the outset that our goal here is not to make our listeners experts this morning, but to provide enough information to allow people to continue a dialogue and exploration. Any one of these topics we could speak on for hours, and there of course have been volumes of material written. So this is mostly a teaser, if you will. So when we talk about the entities that are available out there, one of the questions I often get is, what am I talking about? What is a legal entity? Well, a legal entity is something that can own property in its own name. It can sue and be sued and can conduct a business. A legal entity is really different from an individual, but individuals and entities both have the same ability to conduct business in the state of New Jersey. Now, as far as entities are concerned, there are a number of forms in which to conduct a business in New Jersey. One can form a corporation, and as the slide shows, there's really two flavors there, what some call a SCorp or an SCorp. These are really labels that have come from the tax world. As we'll talk about in a little while, the SCorp is kind of a tax variant on a regular corporation that has some opportunities that are not available to regular or C Corps. And the individuals who own the equity of a corporation are referred to as shareholders. We also have something called a limited liability company, or LLC. It looks a bit like a corporation, has some of the elements that corporations have, and also has some of the elements of a partnership. The individuals who own the equity of a limited liability company are called members. We also have partnerships. There are two kinds of partnerships. There is a limited partnership and a general partnership. The difference between the two is that, as the name suggests, a limited partnership has limited partners. As a matter of state law, a limited partnership has to have at least one general partner and can have a number, an unlimited number of limited partners. A general partner has unlimited liability for the debts and obligations of the limited partnership. Generally, you do not want to be the general partner of a limited partnership. Limited partners have limited liability Their exposure is limited to what they've contributed to the partnership, and their assets outside the partnership are protected from the claims and liabilities from the partnership itself. General partnership is a collection of general partners. As we saw with the limited partnership, where it had one general partner, in the general partnership, all of the owners or partners are subject to the debts and obligations of the partnership. And one partner can be called upon to pay the entire liability or obligation, or all the partners can be called upon to satisfy those debts and obligations. Sole proprietorship really isn't an entity, more of a form of doing business. It's essentially an individual who operates a business in his or her own name without any fancy entity. And we'll talk more about that in a few minutes. We also have in New Jersey and in most states professional corporations, or PCs, where the individual owners are referred to as shareholders. The ability to form a PC and own an equity interest in a PC is governed by state law. The laws of most states which have PCs require that the shareholders be licensed in a particular trade or profession. So, for example, a group of accountants would form a PC to provide accounting or tax services. A group of lawyers as shareholders would form a PC for the practice of law. A group of engineers would do the same. Individuals who are not pursuing a licensed trade would not be able to form a PC, which is really a good segue to how do we form these entities. Well, the corporation, the limited liability company, and limited partnership all require a state filing. In New Jersey, the appropriate form of certificate is filed with the Division of Commercial Recording, used to be the Secretary of State's office, and state law determines the content of those certificates. A fee is paid to the state when the certificate is tendered, and a signature is required on the document. And there's a host of information that's included in this certificate. Once it's filed, the entity is deemed to have been formed. Now, the S corporation, or subchapter S corporation, which I mentioned was another variant of the corporate form, requires another step. I suggested that the SCorp was a tax creature, and that as a creation of tax law, and that would be federal tax law, an election has to be filed with the Internal Revenue Service in order to be recognized as an SCorp. And there are time limits for the filing of that election and requirements as to the contents of the election. And like everything else, the Internal Revenue Service has a form for the election. So be mindful that there is a timetable to that which must be adhered to. The Internal Revenue Service, as most of us know, take deadlines and the calendar very seriously. And my one public service message for today's program, April 18th is coming. Make sure you get your tax returns filed on time. So we've talked briefly about the entities and how these entities are formed. The one we didn't mention, I'm sorry, is a general partnership. That does not require a state law filing. Generally, what people do is file an assumed name certificate with the county clerk's office in the county where the general partnership owns real estate. Beyond that, there's nothing else that's required to be filed. So you've been good enough to form your entity. You filed your certificate. You've gotten a stamped copy back from the Division of Commercial Recording. You've applied to the Internal Revenue Service. You've got your taxpayer identification number. You're now ready to run and operate your business. Most business entities have more than one owner. In the case of a corporation, there may be several shareholders. And questions arise as to how your business entity is going to be operated. How are you going to make decisions? How are officers elected for the corporation, for example? Now, state law is pretty good in providing defaults if you're not good enough or not advised to come up with a shareholders agreement, for example, with a corporation, or bylaws to cover a lot of the basic information. But the best course is for business owners to prescribe the rules for operating their business from the outset. And those rules come in a number of different documents. Some of the documents really depend on the business form that you're using. So for example, in the context of a corporation, we would see a shareholders agreement used. And the agreement would cover a number of different things. State law also looks to the bylaws of a corporation. And the bylaws generally cover things like the number of officers and directors of the corporation, how those individuals are elected, how frequently meetings of the corporation are held, when those meetings are supposed to be held, the notice procedures for those meetings. All of that is prescribed in bylaws. The contents of the shareholders agreement is substantially similar to what we see in the limited liability company context of an operating agreement. For limited liability companies, state law doesn't have an analog to the bylaws, so the operating agreement of a limited liability company tends to be a little more involved than what we see in a shareholders agreement. The same can be said with the partnership agreement, because again, in the partner context, we don't have bylaws, so a lot of the basic governance issues of who's going to make day-to-day decisions that are usually covered in bylaws are incorporated in the partnership agreement. Now, these agreements, at least in New Jersey, are not filed with any state agencies. So the agreements that are made by the owners of an entity as they agree amongst themselves and sign are agreements that are really personal to the owners and the company. These don't really see the light of day unless and until there's some sort of dispute. And then at that point, those agreements are usually appended to a complaint that finds its way into the Superior Court, where a judge is asked to resolve the dispute. Hopefully we never get that far in any of the entities of the folks who are listening to this morning's program. But let's talk for a little while about the things that are included in these agreements. You know, one of the most important things is voting. How many affirmative votes are required to approve a particular course of action, whether it's to appoint a director to a corporation, whether it's to appoint an officer who's among the group of directors of a corporation, how many votes are required to approve a particular course of conduct, ratify a contract, hire an accountant, or determine when to remove an officer or other decision maker from their position. So there are a myriad of circumstances that require votes by owners of entities, and all of those circumstances should be addressed in some governing document. And the percentage required to approve actions does not have to be uniform. You can have bare majority, 51%, required for most run-of-the-mill activities, say the hiring of a manager or the decision to go into a particular transaction, or even to make a distribution of cash to owners. And you can require an even greater percentage for other decisions, such as whether or not to merge the entity with a competitor, or acquire a competitor, or file for bankruptcy, or a number of other significant events. Sometimes that higher voting percentage is called a supermajority, and usually where you have supermajority voting, that is at about 66% or more of the ownership interests of the business entity. The reason you have that higher percentage is that you don't want, bare majority approving what might be a significant change in the business or termination of the business. One of the more important areas, particularly where we talk about conduits or tax flow-through entities, which we'll identify a little later in the presentation, is the circumstances under which distributions of cash are made for the entity. There are some entities here that have owners recognizing taxable income even though they haven't necessarily gotten the cash in their hands to pay the taxes that follow from income recognition. Those entities include partnerships, limited liability companies, and S corporations. Imagine if there was no agreement amongst the owners of the company to allow for a distribution of cash. You would have equity owners forced to recognize taxable income without even the appropriate amount of cash to pay the taxes that come from the income earned by the entity. So it's important to have provisions in the agreement where everyone understands the circumstances under which distributions are going to be made. Many of these agreements will require at least a tax payment be made to allow people to make distributions. Another important area in the governing document is to state the purpose of the entity. Now, there are a lot of entities that are formed under a general purpose, that is any lawful purpose that a business can pursue in a particular state, which for many companies is just fine. There are some entities that place restrictions on the ability of their owners to engage in competitive activities outside of the business entity. And it's in those circumstances where a particular purpose becomes very important. If we just state a general purpose in the entity and the business owners are prohibited from engaging in competitive activities, our business owners would forever be prevented from doing anything except participating in the management of one particular company. Now, if that's their intention, that's fine. But in many instances, it's not what the individual owners intend. So some care in the definition of purpose, particularly if there are restrictions on the activities of owners, becomes important. Again, another good segue to talk about how we can restrict the activities of owners. An operating agreement in a limited liability company, for example, may include provisions that prevent owners from engaging in a competitive business. Agreements don't have to have those provisions, but some do. The benefit is that in the particular line of business that the company is engaged in, the company knows that its members will be devoting all the opportunities and expertise that they have in a particular field to the success of the limited liability company. So that limitation needs to be spelled out in an agreement. The other thing you can provide by way of activities of owners is confidentiality, where the owners agree that the trade secrets, the business information, the things that are proprietary to the entity, the owners agree that these are things that only can be used for the benefit of the business and its owners, can't be used for any side business or side opportunity that everyone doesn't share in, and the owners agree that they will not disclose this information to third parties. So short of some governing document, an operating agreement or shareholders agreement, you're limited in what you can protect of that information. Now, state statute can also affect the ability of the entity to continue if a owner dies during the term of the entity. You can provide in an operating agreement, for example, what happens to the ownership interest on the death, disability, or bankruptcy of an owner. Now, death and disability, the impact might be more clearly understood than in bankruptcy, but let's focus on that for a minute. If three individuals come together to operate a particular business, they may have a friendship between the three of them. They work very well together. But if one of them dies, they may have a concern about who gets the interest of their now deceased owner. Does it become a spouse, a child, some other relative? How does the business dynamic change? Will the two surviving owners be as interested in continuing to operate the business with whoever succeeds to that interest? All of those things can be addressed in an agreement. Again, shareholders agreement or operating agreement or partnership agreement. It's pretty common in those situations to provide that either the survivors or the entity itself has the ability to acquire or redeem the interest of the deceased owner. Sometimes the funds that are necessary to drive that acquisition are provided by life insurance that's acquired during the course of the entity's operations. If you have a particularly labor-intensive business where the owners are the chief sources of that labor, if one of the individuals becomes disabled and is not able to carry their fair share, you might want to consider the ability to redeem or acquire their interest, and your governing agreement would provide a definition for disability, how long the disability has to last, and what the various rights are of both the disabled owner and those who continue in the business. Bankruptcy is another area of potential concern. It has areas of concern similar to divorce, so there's going to be some bleed over in the discussions between these 2 points. When one of the owners files for bankruptcy individually, their assets are subject to the jurisdiction of the bankruptcy court. In some cases, third parties are appointed to place values on assets. Assets including an interest in an entity could be subject to sale. There are questions about the valuation of that interest. Other experts are engaged to assist in determining what the value is. For the very same reasons that business owners may not want third parties in on death or disability, they may also want to redeem the interest of an owner who seeks bankruptcy relief. And your governing document could have a provision giving the business or the other owners the opportunity to purchase the interest of a member who files a petition in bankruptcy. Similarly, if the owner is divorced, the equity interest in the entity also is subject to equitable distribution in New Jersey. You end up with a question of valuation. The non-owner spouses, experts might seek to try to determine the value of the business and the business interest. Suddenly you have a hostile spouse who is involved in the daily operation of the business, investigating books and records, tax returns, cash flow. It's because of that that some consider putting provisions in governing agreements to allow either the entity or the other owners to purchase the interest of a owner who does file or is the subject of a divorce petition. Now, just as the governing agreement can limit the activities of owners while they're owners, it can cover the period of time following their ownership, where they sell their interest to a third party or are redeemed. And it's pretty common for operating agreements to limit the post-ownership competition potential, where a member in a limited liability company, for example, would agree that for some period of time they would not engage in activities that compete with the limited liability company. They won't use confidential information that they gain from their position as a member of a limited liability company, and that they agree to surrender to the company all of the confidential, protected, and trade secret information when they separate from ownership. The governing agreement can also identify what the daily activities of the entity will be, those pursuits which the company can pursue without having to seek permission from its owners, those which require some affirmative vote, and those which require a vote of more than a simple majority. Limited liability companies are generally day-to-day managed by an individual appointed by the members called a manager. Corporations are generally managed day-to-day by a president. And limitations on what a president or manager can do are usually addressed by provisions in shareholders agreements and operating agreements. If we wanted to create any sort of obligations amongst the equity holders or owners of the company as to one another, to say that they had fiduciary duties to each other, duties of trust and loyalty, so that they were always acting in the best interests of the entity and the other members, we would address that in our governing documents as well. The best course, as I said, is to have those provisions addressed in the documents, not relying on state law, although in the last 5 to 7 years, the laws in both New Jersey and Pennsylvania have been revised somewhat, so the state law defaults have improved. But notwithstanding that, best advice is to have a written agreement. The benefit of using a separate business entity is to capture and gather the liabilities of the entity separate and apart from the assets that the individual owners have. Corporations, limited liability companies, limited partnerships as to the limited partners, all create a firewall between the operation of the business and the personal assets of the owners. So debts and obligations remain with the entity, and personal assets that are not contributed to the entity are protected from the claims of creditors. Now that protection isn't absolute. Business owners have to operate their businesses which respect the existence of the entity itself. So an individual, say with two businesses, shouldn't look to move employees back and forth across the two businesses, or commingle the assets of the two businesses, or really commingle their personal assets with that of the business. They should have separate business facilities or office space, separate business personality. If the owners of a business don't treat it as a separate legal entity, the rest of the world won't be obligated to treat it as a separate legal entity as well. The law refers to this as piercing the corporate veil. You never want to be in a situation where your business entity has had the corporate veil pierced, because you'll find that your personal assets are then subject to the liabilities of your business enterprise. Now, the degrees of protection you get really depend upon the type of business entity you form. On the extreme is the sole proprietorship, which provides no protection from the claims of creditors. So the individual who is operating a business in his own name subjects everything that he or she owns to the claims of creditors from the business. The general partnership also affords no protection, and the general partners themselves subject their assets to the claims of their creditors, though it's common to create a general partnership with entities who are themselves the general partners, so that the assets inside the entity that's the general partner is protected from claims. Limited partnerships and PCs have some blanks in there as to liability protection. As we pointed out, the limited partnership has to have one general partner who has unlimited liability for the debts and obligations of the partnership. And PCs do not provide to the professionals protection from the claims that arise from the pursuit of their licensed profession. So a doctor who is a shareholder in a corporation that engages in the practice of medicine can't claim protection from malpractice claims by saying that he operated as a professional corporation or PC. State law requires licensed professionals to continue to be subject to liability from the claims that arise from the pursuit of their licensed trade. Corporations and LLCs offer complete asset protection so that the debts and obligations of those entities don't bleed out from those entities and affect the assets of shareholders, so long as the corporate formalities are observed. So the gold standard, if you will, for liability protection comes from corporations and limited liability companies. Let's talk for a little bit about tax issues. There's really two broad classes of tax characteristics here. One is thought of as a tax conduit. The other is a taxable entity. A taxable entity is one that reports its own income earned from its operations and is itself responsible for the income taxes that arise on the income that it earns. So a taxable entity would file its own tax return, report its income, deductions, loss, and credit on a separate return, have an obligation to pay its own taxes. That should be compared to tax conduit, sometimes called a pass-through entity, which has separate legal existence, engages in its business opportunities, in most cases files its own tax return, but does not itself pay taxes. Instead, the tax aspects from the operation of the business flow through or pass through to the owners. The owners can take distributions from that entity, but generally it's not the distributions that determine when the owners are reporting taxable income. Rather, they're going to report taxable income when the entity earns the income itself. Tax return in that situation is generally informational. The Internal Revenue Service, for example, would receive this tax return and use that information to determine the tax liability of the individual owners. Generally speaking, corporations and professional corporations will report their own income tax, report their own income and pay their own tax liability based on returns that they file. Almost all limited liability companies, all general partnerships and limited partnerships are pass-through entities. So the owners of those entities are going to themselves report their share of the income earned by the entity. Corporation can elect, as I suggested earlier, within certain time frames to be treated as a subchapter S corporation, which, before limited liability companies was the only way you could really get the tax benefit of a pass-through that we'll talk about in a moment, with all the liability protection that comes from the corporate form. Being a creature of the tax law, there are a number of limitations and situations where the S election is not available. There are limitations to the types of shareholders you could have, as well as the number of shareholders you could have. And those restrictions have to be satisfied before an election can be made. In the remaining time that we have, let's talk briefly about the pass-through tax benefits. Why should you think of being a tax pass-through? Well, the chief benefit is the elimination of income tax. What the pass-through does is creates a single level of tax, and it's usually at the owner level. That should be compared to the way corporations are taxed, where the corporation engages in its own business, earns its own income, reports the income, and pays a tax. If a regular corporation wants to put funds in the hands of its shareholders who are not employees, the way it does that is in the form of a dividend. So as you see from the materials, a corporation would pay a 35% federal maximum tax. Dividends would be taxed at 20%, not considering some of the changes that were brought on by the Affordable Care Act. But you have two levels of tax here, 35% at the entity level, and then another 20% when the cash net of the federal tax is distributed. When you consider those two taxes, you've got 52 cents on every dollar available to shareholders after tax. On the pass-through, you've got a maximum tax of 39.6% at the individual level. So net of that tax, and again, we're only talking about federal tax, you've got a little better than 60% left for the shareholders, which is a bit of an improvement on the 52% that we saw where you had to go through two tax barriers. Now, there is some complication for the treatment of what's called self-employment tax. and how it interacts with distributions that come from pass-through entities. I mean, generally speaking, the Internal Revenue Service takes the position that limited partners and members of a limited liability company cannot receive a salary for compensation they receive from the entity. They're only going to take distributions from the entity itself, and those distributions might be subject to the self-employment tax. Certainly in the case of a limited liability company where a member can be actively engaged in the affairs of the company, the Internal Revenue Service is going to look to get some self-employment tax there, whereas on the limited partnership, it's not really possible because limited partners can't participate in management. S corporations, you can have a split personality where you have a shareholder who is both employee and shareholder getting some distributions that are taxed as wages and other distributions that might be subject to self-employment tax. One last point, limited liability companies that have only one member for income tax only can be disregarded, so that if you make that election, you don't have to file federal or state income tax returns for the entity. All of that business activity is reported on the owner's individual income tax return. That makes reporting simpler, but doesn't affect the tax aspects of, the non-tax aspects of ownership. You get the same liability protection that you get from a corporation or a multiple member limited liability company. The sole advantage in that circumstance is tax reporting is much more simplified. So I know that was a mouthful, and we've gone just about 45 minutes and really just scratched the surface. So we've left some time for questions. Vinny, I turn it over to you. What do we have?
Thanks, Scott. It looks like we have a couple questions here already, but I want to give everyone else a moment to type in anything they have. While I'm stalling time to do that, I'm going to remind you about a couple of the panels or tabs on your GoToWebinar panel. So if your GoToWebinar panel is docked, you'll see the orange arrow in your right side of the screen. Bring that out. You'll find the Handouts tab where you can get the PowerPoint presentation. We're actually going to email that to you tomorrow, but a lot of people just want it early, and they get a lot of questions like, how can I get the PowerPoint slides? Click the link right in there, and it'll download right to your computer. The other one right below it is the Questions tab, and you might see that it's docked. If the arrow next to Questions is pointing to the right, just click on that. It'll expand it down, and then you'll be able to write in any questions you have. And don't be shy. The most disappointing thing that I see when I read the post-webinar evaluations, and yes, I read them all, are when people say they wish someone would touch on topic X. We want to make sure you leave happy. You want to make sure you leave happy. So here's your chance. If you have a question, ask Scott about topic X. He'd be happy to answer it. So with that out of the way, let's jump right into our first question that comes from Jimmy, who would like to know, if an LLC and an SCorp are taxed the same way, what difference does it make to me?
Well, Jimmy, I think that the chief difference between the limited liability company and the SCorp is who can be an owner of the entity. As I suggested during the presentation, not every individual can be a shareholder of an SCorp. First, there are limitations on the number of people who can be owners. The limit is 100, whereas there's no limitation at the limited liability company. Most estates and trusts can be members of an LLC, but not shareholders in an SCorp. And non-resident aliens cannot be shareholders in an SCorp while they can be in a limited liability company. So there's certain qualitative limitations that exist between the two. The other difference between the two is how we get money out to an owner. An S-Corp can employ a shareholder so that the shareholder receives wages. Some part of those wages would be used to calculate what was earned for purposes of pension and profit sharing plan contributions. That might also be important to an individual who was trying to avoid a residency determination in New Jersey, who wanted to be a resident of another state, say Florida, for example. If all the services that were performed for the company were in Florida, it might be possible to protect the wage income of an S-Corp from New Jersey income tax, while the distribution portion of amounts earned by the member could never be protected from New Jersey income tax.
We have a question from John who asks, how do you suggest to protect inherited business assets in the event of a divorce?
Divorce and inherited business assets. So I presume that the question is getting to the situation where one of the spouses has received all or a part of their business from some member of their family. That individual is married, and then there is a dissolution of their marriage, and we have the potential for claims of the spouse whose family did not create that asset having some claim against that asset in the course of the dissolution of the marriage, what's called in New Jersey equitable distribution. Well, there are a couple of ways to deal with that.
And he's saying correct.
There's a couple of ways to deal with that. One is to use a prenuptial agreement if that business asset is brought to the marriage, but in most cases, by the time that asset arrives, the spouses have been married for some period of time. The business is then operated for years, and then divorce happens after that. So the prenup wouldn't necessarily work. New Jersey doesn't really recognize postnuptial agreements, though some folks do try to utilize them to at least set out an intention. The best course to follow is really from the outset of when the asset arrives, and that is to place it into some separate entity, a trust, for example, that restricts the ability of one spouse or the other to get at that asset. There are some jurisdictions that have strong asset protection laws, Delaware, South Dakota, Alaska, that allow for the creation of a trust funded with assets which after a period of time are protected from the claims of creditors and aren't subject to equitable distribution in the state of residence. But also impacting upon that are the ability of judges who in New Jersey in the family part sit in equity, who are charged with the responsibility to bring about fair results. And sometimes we set up these legal structures that legally are respected, but that allow judges in certain situations to make certain accommodations to come to what they deem to be fairness. So, John, that's a complicated question, and I think I've just touched on a couple of the areas, but that might be an area that you would want to follow up on offline.
We have two from Clifford, and I'll ask the first one first. What is the difference between a PC and a PA, if any?
A PC professional corporation and a PC professional association, the PAs are usually collections of other entities. So the places where I would see you commonly see a PA are a collection of PCs. The individual licensed professionals are very concerned about ability to protect assets. So each one of them forms their own separate PC, and then those PCs band together in a group as a professional association and operate in that way. You can't, by law, the shareholders of a professional corporation can only be individuals. So what the PA has done is allowed a group of PCs to work together collectively. So the bottom line is that the liability protection is really no different in a PA or a PC, save for the fact that we've injected another entity level. But in the end, we're trying to get at the same thing.
Sounds like Clifford's second question is a little related. What are the maximum number of shareholders in an SCorp?
100.
All right, simple enough. Gwen asks, so listening to your presentation, I think I might have formed the wrong entity. Is there anything I can do?
Well, it is possible to get a do-over, if you will. It depends how deep you are into the life of your business and what you formed. If you formed a limited liability company and you think that a corporation or PC is in order, we can easily convert from that tax conduit or pass-through to an entity that is not a conduit or pass-through. Going from a corporation to a limited liability company, basically the other way, is permitted from state law standpoint and can be done by a conversion, but there could be tax issues that are involved because the conversion from a corporation, for example, to a limited liability company is treated as if the corporation were dissolved and the assets contributed to the LLC. The tax law looks at the dissolution of an entity as a taxable event. So the difference between the investment of the shareholder in the corporation and the value of the assets at the time of the dissolution would give rise to taxable income upon which taxes are paid. The problem is that the individual really hasn't increased their wealth at all. It's not like they've sold the business to a third party who gives them a bunch of cash for the purchase. This is really a situation of phantom income. So the conversion the wrong way could give rise to a tax liability. If you're in that situation where you probably should have been a pass-through but aren't, you can start a new business under, limited liability company and let the corporation kind of die on the vine, so to speak.
From Helen, why are so many companies formed in Delaware?
Must be something in the water in Delaware, Vinny. There is a perception in the marketplace that Delaware is the best place to form a corporation. Well, unless you're General Motors or Alcoa or some other publicly traded entity, or think that you're going to be the target of takeover by a private equity fund or a venture capitalist, there's really not a lot of justification to go to Delaware. In a lot of instances, their franchise fees are higher than what you pay in your home state, and any tax savings that you think you're accomplishing by forming in Delaware are usually defeated because those Delaware entities qualify to do business in another state, New Jersey, for example, because that's where their office space is and their employees are and their business activities are. And doing business in New Jersey creates what's called tax nexus, so you end up paying New Jersey income taxes as well. So now you have two separate filings, one in Delaware, one in New Jersey. You're still paying the New Jersey tax, and you have to deal with the Delaware franchise fee. So net, you end up with a higher cost of doing business. Again, unless you're one of those entities that's going to be taken over, by the private equity fund, you're probably better off just staying in New Jersey.
Roberto asks, if I have a corporation with one other shareholder and we have a disagreement, how is that resolved?
Well, I guess that largely depends on whether or not you have a shareholders agreement or not. The shareholders agreement could set out a means for resolving disputes, particularly where there's just two owners and the owners each own 50% of the shares of the corporation. The shareholder agreement could provide for the appointment of a third person to mediate the dispute. Sometimes if two individuals can't agree on a course of business, they're also not likely to agree on who it is who'd come in and resolve their dispute. So the agreement can say that the rules of the American Arbitration Association, for example, would assist them in resolving the dispute. A time frame would be set up for the shareholders to meet amongst themselves to give them the chance to make reasonable attempts to resolve their differences, and if they couldn't, the third-party rules would appoint someone to come in and hear from both sides, make a decision which both sides are then required to follow. And if that arbitrator's award isn't followed, it could be enforced in court. So the shareholders agreement could provide for resolution, and that resolution doesn't necessarily exist, as a default under the state corporation law.
Could always go rock, paper, scissors. We have enough time for one more, and we actually don't have any more questions, but I thought we had actually done a video with Scott earlier in the month promoting our this webinar, and our Chief Communication Officer, Peter Peretzman, asked him a great question that I thought maybe he could share here for those who didn't see the video. He asked, for the average business, maybe you're setting up a cafe or something on Main Street, what would be the best kind of entity or classification to choose? And obviously you have to do the research, but for most people, what do you find is the best?
I think my entity of choice is limited liability company, primarily because of its flexibility. You can do almost anything with a limited liability company. I can have different types of owners with different rights. I have no limit on who can invest in the limited liability company. All of that flexibility, even in light of the differences between that and the SCorp, where the SCorp allows me to have an owner who takes a wage and distribution, isn't enough for me to say go the SCorp route. Either of those choices gives you liability protection, but I would say that limited liability company because of the flexibility is my first choice.
Awesome. So that looks like about all the time we have, so I think it's as good a time as any to bring things to a close. Don't forget, all of you will be receiving a recording of today's webinar and the PowerPoint slides via email. Lastly, when you close out of the webinar, a survey will come up on your screen that we hope you will fill out so we can understand how best to provide you important information in a webinar format. Our next webinar, NJBIA Live from the State Capitol, will take place Wednesday, May 10th, and will feature our very own Sarah Bloom covering the latest environmental and energy issues impacting your business. So until next time, for Scott Borsack, this is Vinny Civitello thanking you for being with us this morning and wishing you a good day.